Good afternoon, everyone, or good morning, or good evening, depending on where you are. My name is Arif Jamal. I'm the Deputy Director of the Center for Asian Legal Studies, or CALS, at NUS Law School. And I have the great privilege of being your moderator for today's virtual roundtable on Asian law, focusing on freedom of religion and belief. Before we begin the main event, I just wanted to spend a few moments introducing the virtual roundtables. I will then introduce our panel and talk about how we will proceed. This is the sixth of the virtual roundtables on Asian law being hosted by the Center for Asian Legal Studies, with more planned. The roundtables are part of the Center or CALS's response to the current restrictions that we all have on traveling, but also an effort to try to make sure that discourses around and about Asia continue to be heard and stay at the forefront of academic debates that are happening. Today's roundtable is a very significant, addresses a very significant topic, and we have a very distinguished group of panelists with us. I welcome them on all of our behalf. I thank them for being here. And I will give a brief introduction to all of them in the order in which they will be speaking. Our first speaker is Dr. Nazila Ghanea from the University of Oxford. She is the Director of International Human Rights Law Programs at Oxford and a co-author, amongst others, of the Oxford University Press monograph on freedom of religion or belief in international law commentary. Speaking after Naz will be Benjamin Schonthal from the University of Otago. Ben Schonthal is Associate Professor of Buddhism and Asian Religions, as well as being Associate Dean International in the Humanities Division at his university. Ben's research examines the intersection of religion, law, and politics in Southern Asia, and he's the author of a very good manuscript called Buddhism, Politics, and the Limits of Law, which came out by Cambridge University Press in 2016. After Ben comes my friend and colleague at NUS Law, Dr. Jaclyn Neo. She's an associate professor and actually the director of the center, the Center for Asian Legal Studies. Jaclyn's work embraces law and religion, but also has a specialization in comparative constitutional law. And last, rounding out our panel, but not least by any estimation, is Mark Hill. Professor Hill is an adjunct or visiting professor at a number of different places, including the Center for Law and Religion at Cardiff University and King's College London. And he practices at the London Bar and holds judicial appointments in both the ecclesiastical and civil courts in the UK. So on behalf of all of us here, thank you to the panelists. So now it's my happy task to move on to the main event and turn the floor over to Nazila for her presentation. Naz, thank you.
Thank you very much, and thanks a lot to CALS, to Arif and Jaclyn for having us here and drawing our attention to this important topic. I have to say, Arif, your reference to the end of time sounds a bit ominous in the context of religion, but yes, I will keep to time. So in this session, we're each addressing different conceptions of freedom of religion or belief, and I'll just be offering some preliminary remarks on this right, particularly its international capture, and drawing some general observations about where it seems to flourish and where it seems to be restrictive. I'm glad of Benjamin's specialization because perhaps in the Q&A he will also detail and provide his views on some of these observations. Freedom of religion or belief is a fundamental human right that has been enshrined in all international human rights instruments, but also at the regional, at the domestic, and even at the provincial levels throughout the world. You know, some of them are more partial understandings of freedom of religion or belief as understood in international human rights law, but it doesn't remain unaddressed. Article 18 of the Universal Declaration of Human Rights upholds that everyone has the right to freedom of thought, conscience, and religion. This right includes freedom to change his religion or belief, and freedom either in community, either alone or in community with others, and in private or public, to manifest his religion or belief in teaching, practice, worship, and observance. This is then becomes legally binding in Article 18 of the International Covenant on Civil and Political Rights, a covenant that has been ratified to date by 173 state parties. I'll just read part of that article. Everyone shall have the freedom of thought, conscience, and religion. This right shall include freedom to have or to adopt a religion or belief of his choice, and freedom either individually or in community with others and in public or private to manifest his religion or belief in worship, observance, practice, and teaching. The next article says that no one shall be subject to coercion, which would impair his freedom to have or to adopt a religion or belief of his choice. The next talks about the limitations that may be imposed on manifestation of religion or belief, and the final subpara about the rights of parents. We observe already from this that freedom of religion or belief can be practiced with others and in public. It is not only a right that we hold, but also one that we can manifest. So therefore, we can already see that freedom of religion or belief is not just a negative right. It does not just require states to fail from intentionally or otherwise restricting or violating this right. It also calls upon positive duties. Positive inducements are necessary by the state to create an enabling environment for the enjoyment of this freedom by all, not least in relation to manifesting it along with others in public and in the possibility of the free investigation and change of religion or belief. To make these meaningful, many positive contributions and vigilance by the state is necessary, because this is a dynamic environment where change is always occurring. So in the few minutes that I have, I want to turn my attention to a key factor that impacts this positive role and in the facilitation or inhibition of freedom of religion or belief. There is academic literature that has focused on the state-religion relationship and the impact this has on the enjoyment of this right by everyone. A starting point for considering this, we can already go back to the Arcot Krishnaswamy report of 1960, who very richly outlines that and draws attention to that. Or we may draw more recently from General Comment 22 of the UN Human Rights Committee that makes a number of very pertinent points, including in paragraph 9. It says that the fact that a religion is recognized as a state religion, or that it is established as official or traditional, or that its followers comprise the majority of the population, shall not result in any impairment of the enjoyment of any of the rights under the covenant, including Article 18, freedom of religion or belief, and 27, minority rights, nor in any discrimination against adherents to other religions or non-believers. UN Special Rapporteurs Heiner Bielefeld and Ahmad Shahid have also drawn attention to the state-religion relationship in their reports and its consequences for the enjoyment of freedom of religion or belief by everyone, especially those others or non-believers that General Comment 22 already drew attention to. So important though the state-religion relationship or the state-belief ideology relationship is, perhaps it has taken the focus, advocacy and research away from an equally pertinent question, which is the form of government itself. And I'd like to suggest that we should actually twin these together. It's not only the relationship of the state with a particular religion or ideology, but also the form of government that fuels this. And that combination, I would say, has greater consequence rather than if we consider only one of these. In the human rights and freedom of religion or belief literature, the relevance of the form of government has perhaps been de-emphasized, or not enough attention has been given to it, and more attention has been given to the state-religion relationship. But perhaps this has proven problematic because it has obfuscated in the same measure that it has illumined this debate. In the book that Arif kindly mentioned, co-authored with Heiner Bielefeld and Michael Wiener, we propose the concept of respectful distancing between the state and religion or belief. The term distancing here was only used by us to refer to the disentanglement with religion or belief legally and politically, but not socially. The objective is to positively and continually invest in creating space for free holding of religion or belief without fear and discrimination. So in our book, we consider a number of states, and we consider Iran, Saudi Arabia, Bhutan, Greece, Cyprus, Moldova, and India. And in short, we observe that just the proclaimed relationship of the state with religion or ideology is far from sufficient to detail its entanglement, whether in the educational field, in taxation, in the rejection of conscientious objection, in religious accommodations in the public sphere, or hostility, whether state-driven or bottom-up. And so how can we understand this gap between the announced state and religion or belief relationship, and how freedom of religion or belief actually fares on the ground for everyone, for individuals, communities, and at all levels? One way of digging deeper, I've suggested, is to carry out much deeper investigations in understanding changing patrimonial relationships between the state and religion or belief at different levels. So the focus would be on the religion or belief patrimonial relationships, where authority and power flows from and relates to religious or belief affinity with the ruler or the ruling establishment. A study of these relationships, combined with established or emerging authoritarian or dictatorial tendencies, may offer much more accurate understandings of affiliations and the consequences for the enjoyment of human rights, and particularly freedom of religion or belief. We observe in our monograph that religion or ideology may be instrumentalized for the purposes of building identity, unity, or social homogeneity by tapping into feelings of religious belonging for the purposes of strengthening political loyalty, thereby also seriously risking discrimination and hostility against others. So it seems to be this combination of patrimonial relationships and authoritarian and dictatorial tendencies that may create an impossible or highly restricted environment for the full enjoyment of freedom of religion or belief for all, let alone its enjoyment without discrimination and on a basis of equality. Any kind of symbiotic relationship here gives rise to human rights concern. This might be at the legal level, the political level, the social and cultural levels of life, or all of the above. So returning to general comment 22, what form of government can deliver no impairment in the enjoyment of any of the rights in the covenant, including the enjoyment of freedom of religion or belief and minority rights? What form of government can ensure this, regardless of belonging to the majority religion or various minority religions, other religions, or being deemed a non-believer in that context? We might look here to family law, to criminal law, educational law, burial law, tax law, and many spheres of life, parliamentary representation, education, personal status, child rights, etc., and look at non-discrimination in these arenas. In this sense, therefore, the question of discrimination on the basis of religion or belief also draws our attention to the form of government, not only the state-religion relationship. In our monograph, we observe that we need to ensure that the state does not resort to religious exclusivity or bias in culture, identity, schooling, or even symbolism for short-term ends and for vested interests, but that the state will continuously strive to create spaces of inclusiveness for all as an active and ongoing endeavor. So in this panel, we've been asked to focus on different conceptions of freedom of religion or belief and how they operate in Asian and non-Asian contexts. This is a very important area of inquiry, but I've just suggested that we shouldn't forget the state, the government, the form of government and the politics that may be forging or shaping only a singular or particular models of religion or belief survival in that context. So in our deliberations today, we should also be mindful that freedom of religion or belief pushes against political efforts to control, benefit from, and direct religion or belief for other ends. Thank you.
Thank you, Naz. I turn now to Ben Schonthal.
So thank you to Arif and Jaclyn and to Finna and others at NUS, and thank you indeed to those of you who showed up this New Zealand evening. I'm going to, thank you Naz for those wonderful comments. I'm going to build on that a little bit in my comments for today. Right now, I think there's a nice point of intersection. Since the start of the pandemic, countries throughout the world have been struggling to find a balance between religious freedom and public health. Remarking on this issue in Southeast Asia, some commentators have marveled at the seemingly broad popular acceptance of emergency restrictions placed on religious activities. Buddhists have been regularly singled out. Articles like this one in The Economist have insinuated, if not overtly claimed, that Buddhists have a special attitude of compliance with emergency laws, and that this attitude in part has protected Buddhist majority jurisdictions from the worst ravages of the pandemic. Now, to some, all of this may sound eminently plausible, given Buddhism's popular reputation for being an otherworldly religion, and the common imagination of Buddhist monks as solitary seekers of enlightenment. But to those familiar with the region, a simple equation of Buddhism with passivity and political quiescence doesn't hold much water. After all, in recent years, Buddhist monks themselves have been extremely active in politics and regular litigants in religious freedom cases. Given this, how else might we think about the ostensible posture of compliance among Buddhists, particularly among Buddhist monastic groups that in previous years have actively challenged local governments and national laws? I'm not going to provide a satisfactory answer to this question tonight. The question, after all, is far too large to address in this one setting, and there's probably no monocausal answer. Nevertheless, I want to use this question as a springboard for reflecting on the scholarly study of religious freedom more broadly, and for questioning the presumptive singularity of the category itself. So here's my proposal. Rather than thinking of religious freedom in unitary terms, I suggest that we should stretch the category along two axes, depending on how we invoke the phrase and where we do so. In terms of how we use religious freedom, I think there are at least two possibilities. Most obviously, religious freedom can be invoked as a formal rubric of public law. That is a category and concept of state and transnational law, similar to what Naz was talking about previously. But it can also be invoked as a freestanding cultural construct. That is a set of culturally specific orientations or concepts that are thought to approximate the legal category itself. And in terms of where we use religious freedom, two specific domains should stand out: inside formal public legal settings and outside of them. By paying attention to the nature and function of religious freedom in these different settings and in these different uses, four different modalities of religious freedom might be visible. If we take the formal settings of public law, courtrooms and legislatures, for example, religious freedom can be deployed in two modalities: Most obviously, there will be the deployment of religious freedom as law itself, which is to say, as constitutional or international legal principles usually defined by rights to freedom of belief and manifestation, often with certain limitations around them. At the same time, public law discussions of religious freedom have as their goals the extension of formal legal rubrics to supposedly naturally occurring cultural forms. So religious freedom litigation, therefore, does not simply entail abstract analysis of legal rubrics, rather it attempts to correlate those rubrics with, or map them onto, pre-existing features of cultural practice. For example, when questions about acceptable limitations on religious freedom in Indian courts give rise to and intersect with culturally specific debates about what is an essential practice in Hinduism. Now, outside of public law settings, one can also point to different uses of religious freedom. In public rallies and political protests, religious freedom is often burnished in its public law sense, with participants asserting, in the American case, for example, their First Amendment freedoms or their international human rights. But what about this last modality? What does the cultural construct of religious freedom look like outside of courts, before it's called to account for itself as religious freedom in the context of litigation? It's this modality of religious freedom that I think has been least examined in what I would term the three major waves of religious freedom scholarship that we've seen in the academy. Sorry, I'll just put that up there. In the first wave, we focused on the legal rubric in legal spaces, concentrating on the development of law, jurisprudence, and doctrine. In the second wave, we've considered more closely the potential misfits between these legal categories and the diverse practices of religious communities in various parts of the world. Most recently, we've seen a third wave of scholarship that concentrates on what's often termed the politics of religious freedom. That is, the multiplex ways in which appeals to public law can justify or undercut the power plays of governments and non-governmental groups. Lagging behind all of this, to my mind, have been legally minded inquiries into the ideas and practices outside of courts that might act in ways parallel to religious freedom. This includes, among other things, features of religious law. Scholarship in this area may constitute a fourth wave of religious freedom scholarship, although it's been going on for some time, and indeed Mark has been very active in this space. Nevertheless, I would suggest it lags behind, and nowhere more so than in the case of Buddhist law. So why does all of this matter? Well, let's go back to the question we started with. How might we explain the ostensible acceptance of emergency restrictions on religion by Buddhists using this way of thinking? Well, we only learn so much from looking at the three darkened boxes here. Nothing has really changed about religious freedom laws in these areas. There's been no litigation and a notable absence of rallies. What then of the fourth modality of religious freedom, in the form of parallel or cognate notions in Buddhist law? Here we can find some traction. Over the last few months, I've been following media commentary and social media accounts of some monastic groups in Sri Lanka. And on more than one occasion, I saw reference to a somewhat arcane principle of Buddhist monastic law that was being used to understand and justify limitations on participation in what would otherwise be obligatory Buddhist practices. The principle appears throughout the oldest and most prestigious text of Buddhist monastic law, called the Vinaya Pitaka, and it takes the form of a broad exemption that the Buddha applies to many rules of behavior, even important rules, such as the injunction that a monk must wear saffron robes. The exemption states that monks may temporarily ignore these normal obligations during situations of danger. The Pali word for this, the liturgical language in which the text is written, is sasanka, a term that literally means something which is harrowing or suspicious. One of these lists of harrowing or suspicious things includes the following: threats from kings, threats from thieves, fire or water, threats to human beings, threats from human beings, from supernatural entities, animals, insects, or dangers to human life or to the monastic life. By these standards of Buddhist law, COVID-19 certainly qualifies as one of these exceptions. This is the point I'm hoping to leave you with. If we want to understand how religious freedom works in Asia, it's not enough to search under the lamplight of public law categories and contexts. Doing so, we might mistakenly interpret a lack of public legal activity as full acquiescence to state laws, rather than the principled compliance with other normative orders. We might inadvertently naturalize public law conceptions of religious freedom while ignoring other important cultural cognates that, although they incentivize similar behaviors, are not fully homologous with nor derivative from those public law conceptions. Moreover, we might blind ourselves to a crucial area of overlap between the religious and the legal, namely religious legal orders, which may be less visible in the public sphere, but equally, if not more consequential, in the private. Thank you.
Thank you very much, Ben. Let me turn now to Jaclyn.
Hello, everyone. Again, thank you for joining us today. Ben's talk really sort of sets up what I'm about to talk which is freedom of religion and belief, but from a sort of communitarian perspective. Now, I think that when Ben was talking about cultural cognates and sort of religious law, well, in a sense, what my talk is going to be about is to look at how religious groups respond to different sort of social contexts and political contexts, and how that actually manifests itself in the discourse that they engage in. Now, one of the sort of central claim within religious freedom scholarship is the idea that religious freedom is largely rooted in the idea of personal autonomy. And the conception of religious freedom as rooted in personal autonomy is a dominant view, especially in international law, which can provide very powerful claims against perceived state encroachment of that autonomy. Religious liberty is commonly described as being sort of associated with a right of self-determination, as Alan Brownstein has described it, or as associated with self-fulfillment, as being part of one's basic autonomy of identity and self-creation that is meant to be preserved from state encroachment and state manipulation. Now, there are, of course, some emergent problems with this conceptualization of religious freedom as personal autonomy. And one important critique is that, as Michael Sandel, for one, has pointed out, is that it takes away the special character of religion under the law. It's just simply a matter of personal choice. Or, as Stanley Fish, in his characteristic sharp wit, has said, in criticizing what is considered to be the liberal principle of religious freedom, that it ends up prioritizing individual choices, it emphasizes the privatization of religion, and appeals to what he calls squeamish religions. And so an individual-based conception of religion of religious freedom could be criticized for undervaluing the collective and communitarian dimensions of religious practice. And we can see in the formulations, even in the Article 18 of the ICCPR, which Nazila was mentioning, there is an emphasis which starts with everyone or every person. But again, we must not overstate this claim, because at the same time, even if we look at Article 18 of the ICCPR, there is a recognition that this right is being includes the freedom to manifest one's religion in worship, observance, practice, and teaching individually or in community with others. So the communal dimensions of religion cannot be ignored. But at the same time, there is often an emphasis on the individual dimension, such that the communal dimension tends to become secondary. So if we were to sort of take a very individual orientation of religious freedom, one may then say, may criticize this as overlooking a much more dynamic relationship between the individual, the religious community, and the state. So a broader sort of discourse on liberalism has entailed a challenge from communitarian theory, which has stepped in to try to mitigate what some consider to be excesses of hyper-individualism. To be clear, there are variations and permutations of communitarian thought, But there is at least this sort of commonality in that communitarians oppose the liberal claim that each person ought to determine the good individually. Instead, communitarianism stresses that individuals are socially embedded and have social responsibilities to each other, to their communities, and for the common good. Now, this disagreement about the self, whether contextualized or situated versus unencumbered, lies at the heart of this debate. And of course, communitarianism itself is not without its critics. One of the strongest criticism is that communitarianism tends to slide into authoritarianism. And so communitarian states, self-proclaimed communitarian states, have been accused of using the coercive powers of the state to subordinate individuals for the sake of religious harmony and so on. And so there is sort of an attempt to try to differentiate authoritarian communitarianism from what Etzioni and Galson calls the responsive communitarianism. Now, what would a communitarian perspective that is not authoritarianism, but at least a communitarian perspective that emphasizes the community over the individual look like? And how does that sort of shape and approach to religious freedom? In this regard, I'm going to move to the example of Singapore, which to a large extent is a self-proclaimed communitarian state. For instance, in a 2016 speech that the Chief Justice himself delivered to the American Law Institute, he observed that the fidelity to the rule of law in Singapore coexists with an emphasis on communitarian over individual values. And this includes a preference for dialogue, for tolerance, compromise, and the placing of the community above self. And so under this view, there's a strong emphasis that religion plays a role in advancing the common good. And this is interesting because here what we're doing is to look at religious groups as having not just rights, but actually having responsibilities to the community. And this really manifests itself in the way that they have responded to the COVID-19 outbreak. So allow me to sort of point to a few examples to show how a communitarian perspective has shaped the religious group's internal perspective and its external engagement with state and society in general. The outbreak, the COVID-19 outbreak hit Singapore quite early on, and Singapore started to sort of put in place certain restrictions, starting, with minor sort of travel restrictions at the end of January, and then eventually major restrictions in early April, what we call the circuit breaker. Not a lockdown, but a circuit breaker. But what is interesting is that we see that initial closures of places of worship actually occurred at the religious group's own initiative. The Catholic Church was among the first to announce closures. More than a month before the government imposed certain restrictions on places of worship, the Catholic Church suspended its weekday and weekend public masses. Unless you think this is only an initiative by traditional churches, other churches, including one of the mega churches in Singapore, had also sort of moved to their services online. Similarly, quite early on, the Islamic Religious Council, granted a public agency, actually announced the closure of mosques, which was meant to be temporary initially, but then this was extended. Now, one may see these closures as a way for religious groups to protect their own congregants. After all, some of the earliest and at some point largest clusters of COVID-19 cases in Singapore were in churches and later in the mosques. But I think the response really goes beyond self-interest. And this is reflected in the way these groups actually characterize their own responses. And the characterization of their responses really was to, as a way to show that they are responsible members of society, that they are exercising responsibility not only to their members, but also to the community. Let me give you a few examples of the statements made. For instance, the megachurch, when they moved their services online, said, "Our congregation is not small. We have members young and old, and we need to protect them. So exercising or displaying responsibility to their members. Interestingly, the Fatwa Committee of the Islamic Religious Council even issued a directive, a fatwa, to to explain the permissibility of mosque closures and suspension of Friday congregational prayers, very much like what Ben was talking about in terms of providing an internal justification for taking certain public health and safety measures. Secondly, I think very interestingly is that these religious groups also sort of emphasize their responsibility to the community and a commitment to the common good. So when the Catholic Church first announced suspension of Mass, the Archbishop issued a statement saying, as Catholics, we need to be responsible in playing our part to contain the spread of this virus by avoiding large gatherings of people. Later on, when they decided to continue the suspension of Mass, he issued another statement saying, as responsible Catholics, we should be mindful that we do not do anything that might further burden the already strained healthcare system. And as the head of the Catholic Church, I have to decide for the common good. So it's very interesting here. As the head of the church, I nonetheless have to decide for the common good of society. Now, these statements, and there are several others, reflect and I suppose engender we are in this together mindset, that we are not just looking out for the interests of our members, of our congregants, but we're putting forward this idea that we, the religious organizations, the religious community, are part of this bigger community, and that we are socially responsible institutions. Also,
one minute, please.
Yes, I'm going to sort of end with this.
Thank you.
So I think that there is a serious critique about a communitarian perspective to understanding the relationship between religious groups and the state. Some may see this as, you know, a strategic response to a framework of control in an authoritarian context. But I think that will miss a very key aspect, which is that religious groups are not simply subjects of the law. They are also agents of the law. They shape, while they may shape their own values to accommodate social and legal norms, they are also in the process of shaping those norms. And we see this in the way they have responded to the crisis and in the way that they have responded to the situation that we see arising from COVID-19. And so in a sense, this communitarian perspective on religious freedom should not be seen as simply a matter of state imposition, but also something that is being shaped by the perspective of religious groups as well. Thank you very much.
Thanks very much, Jaclyn. And now to bring us all home, Mark Hill.
To bring us home brings us to London on a typical summer's day, where it is grey and wet and overcast. So my thoughts go out to you in Singapore and to New Zealand respectively. Thank you very much to NUS and to Arif for arranging for this seminar. Thank you for my fellow speakers who have set the bar incredibly high. I'm going to stick perhaps more rigidly to the original briefing paper as suggested at the outset, and to speak in three distinct sections, to narrate, to situate, and to evaluate. To narrate by saying my particular angle and viewpoint, because the great genius of the work being done through the Center for Asian Legal Studies is its comparative global outreach. To situate that argument within the current position, both globally with the pandemic and in the United Kingdom, and then to attempt some form of evaluation and a direction of travel. I did prepare a written paper that may be available to participants at a later stage, but working on preparing for today and beyond, I realize very much that we are trying to hit a moving target. And even since I did my original draft, things have changed, and I think they'll change in the future. But so far as the narrate section is concerned, as Arif made clear in the introduction, I practice law in this country representing clients and sit judicially hearing various cases. And my point of focus is on the grounded reality of how these types of cases, types of disputes, and differences of viewpoint are negotiated in practical terms by the courts from day to day. So that's very much one tiny part of the overall modalities which Ben drew attention to in his presentation. But being based in Europe, it's fair to say, just to be brief by way of overview, that there is no single model of church and state common throughout Europe. Each is different, and each is dictated by its history, by its culture, and by its ethnicities. But within all those different practical systems of church and state, the underlying principle which seems to emerge is one of cooperation between state authorities on the one hand and religious organizations on the other. And what varies across national borders is the degree to which that cooperation allows both the state to flourish and the religious groups within it also to flourish. And the prevailing ethos is a liberal one. The state will generally facilitate religious organizations and will afford them a high level of autonomy to arrange their religious affairs as they see best. And across the totality of Europe, there are two key legal instruments which merit discussion. One is Article 9 of the European Convention on Human Rights, which provides a substantive legal right to freedom of religion or belief, which is justiciable in many domestic courts of the states of the Council of Europe, but it is also regulated by an international treaty and an international court based in Strasbourg, which ensures that states comply with their legal obligations under the convention. Running in parallel with that are provisions of European Union equality law, which prohibit discrimination on a number of grounds, which include the ground of religion being what is called a protected characteristic. And the combined effect of those two principles, the general freedom of religion and the anti-discrimination provision, really dictates the framework within which religious organizations are free to operate. Now, how do we adopt that framework and how do we view it when we have the current challenge of an international public health crisis? And this is where one can observe anecdotally, as the other speakers have done, as things have developed, and try and predict for the future how things may develop as the pandemic runs its course. Now, I venture a number of general observations which may be of universal application, but I certainly see them present in the United Kingdom. I see echoes of them elsewhere in Europe, and I think also we see similar principles emerging elsewhere in the world. Now, my first point is that as the COVID emergency has taken its course, the state has become less liberal, while religious organizations have become more liberal. Now, that was certainly the case in the early days, when there was a real fear and an unknowing as to the reach and the intensity of the COVID-19 pandemic. States were obliged to place limitations on the civil rights enjoyed by their citizens, restrictions on movement, restrictions on education by the closure of schools, on marriage, on travel, and on non-urgent medical treatment. By common consensus, it was the greatest curtailment of civil liberty in peacetime. And it came about, in effect, by placing the vast majority of the population under house arrest. One could only leave one's place of residence for certain limited exceptions. Of course, as the lockdown has eased, those things have changed, but the original imposition of the restrictions were incredibly severe. And as some of the speakers have already observed, the religious organizations, for the most part, have been complicit in the state's curtailment of those civil freedoms, but they have been relaxed in relation to their own internal doctrine, internal polity, and internal regulation, in the matters which they have seen as being of significance have been waived or dispensed with for the common good and for the good of individual practitioners. So, for example, the Eucharistic celebration, the sharing of the elements of bread and wine, has had to have been suspended, and that has been done to a large extent willingly as a gesture on the part of the religious leaders, as has already been identified, to lead the way in terms of activating the common good. And I quote in my paper from a briefing document issued by the British Board of Scholars and Imams, where they state, and I quote, "We take seriously our responsibility to minister to the welfare of the community, both worldly and next worldly. This involves a recognition of the serious importance that our religion places on life, health, community, and spiritual well-being. To trivialize any aspect of this would be an error." And then it goes on to say, "In the event that government directives are issued overriding any part of our internal Muslim guidance relating to gatherings in public or in private spaces, then the government directives would take priority." So that's an example, and it's one of many, of a religious organization placing itself beneath the authority of the government in terms of the immediate steps which are necessary to combat, or at least live with, the threat of the COVID-19 pandemic. My second general point is that the state has been forced to learn the language of religion. In the years I've been working professionally in this field, my constant complaint has been that there is a religious illiteracy in government, both central government and local government. And it's often difficult for churches and other faith organizations to engage with the government because they tend to speak entirely different languages. So for negotiating exemptions from general laws, the first step that religious organizations have had to do is to educate government in what their doctrines and beliefs require of them. And because it's not a hostility that one sees in the part of government, it's an ignorance. And that ignorance needs to be abated by the learning of language. Equally, in terms of the sheer mechanics of language, I note that the guidance for the safe use of places of worship, which was issued by the government in this country on the 4th of July, was published simultaneously, not merely in English, but in Arabic, Bengali, simplified Chinese, traditional Chinese, French, Gujarati, Polish, Portuguese, Punjabi, Romanian, Somali, and Urdu, recognizing, as is inevitably the case, that we live in a plural society, which is multicultural, multi-ethnic, and a country which speaks a great many languages. Hence, the need to communicate is done in that way. And in addition to that, the guidance issued by government shows that it has listened to religious organizations and expressed these growing limitations, often in language which those religious organizations can use. There are priests and imams who might take exception to being called, quote, venue managers, but there needs to be some generic term such as that in order that these individual places of worship, covering a vast number of different faiths and different faith communities, can be controlled in some way. And of course, the other impact on freedom of religion is that whereas hitherto people have been entitled privately to attend acts of worship, now that churches and other places of worship are being opened up, records have to be kept for 21 days of those who are attending. People have to declare their names and identities, not because of any suspicious government need to control, but because of the track and trace need to follow up in the event that there is a localized further outbreak of COVID-19. And so
Mark, 1 minute, please.
The positive aspect which one can see from this is that religious organizations are learning new and better ways of collaborating with churches. This is happening locally, and it's happening much more the case by local groups talking with local governments to see what exactly it is that they need. Now, I've said that this is a moving target, and I believe it is. There have been various cases brought to court dealing with the sense that there is an excess of government intervention and that religious groups and religious individuals are being disadvantaged. What I detect as of today's date is a subtle change of direction in that the individuals are becoming more assertive in relating to their rights and are less willing to accept without question expert advice and government direction that they do or refrain from doing other things. And I finish with this observation that as of yesterday, one of those first instance cases which was dismissed by the judge on the basis that the balancing of Article 9, the freedom of religion on the one hand, and its right to be manifested subject to limitations such as public health, is to be heard in our Court of Appeal the week beginning the 28th of September. And the courts at a higher appellate level are going to start the process of evaluating whether the correct balance has been drawn in terms of proportionality between the need on the part of the government to protect citizens from the growing public health emergency, and on the other hand, the clear constitutional right of individuals and of groups to assert their religious identity. So I finish just by saying this: watch this space.
Thank you very much, Mark. Watch this space indeed. And thanks to all of the presenters. I was very much hoping that we would have about half an hour left for questions, and we've got exactly that, it seems. Begin with the first one, which is that I have, which is to Jaclyn. It's from Akihiko Morita from Japan. The question is, I agree to your idea, seeing religious groups as not only subject of law, but also agents in lawmaking. In this connection, how do you think the public sphere for law or stroke policy making should accept and accommodate religious belief based on the justification of public discourse aiming at certain legal provisions?
Thank you for that question. I suppose if we see religious groups as being legitimate actors in the public sphere, and in a communitarian setting, I think that it is much harder to sort of insist on this privatization of religion or this sort of strict separation of religion and the public sphere, religion and politics, then one will have to be quite open to religious groups having a voice in the formulation of public opinion, in the formulation, and to the extent that it is being accepted in the formulation, in being taken, and their views being taken into consideration in public policy making. Now, what I think would be very important, and this is sort of something I did not manage to start to speak on, is the need to ensure that even in those circumstances, religious groups do not have a dominance or monopoly over public discourse, which means that we need to sort of have be able to see religious groups as legitimate actors, but not as prioritized actors in the shaping of public discourse.
Thank you, Jaclyn. So the second question also from Professor Nazila, but it's for Nazila, and the question is, how do you think democratic government representing a majority of people can restrict the despotism of the majority, perhaps tyranny of the majority belonging to a mainstream religion in a given state, with the exception of constitutional constraints?
Thank you, Arif. And if you don't mind, I've also looked at the Q&As, and there's a bunch of questions that ask me to comment on particular contexts like Vietnam, China, etc. And, you know, to be sat in Oxford and be commenting on that, where I've suggested that we should be assessing things constantly on the ground with vigilance, doesn't make a tremendous amount of sense, nor is it my expertise. But I do want to draw attention to the non-negotiables. 176 states have ratified the International Covenant on Civil and Political Rights. And of course, that's not the only source of accountability. There's also the Universal Periodic Review and other legal instruments, including, as this question drew attention to, the country's own constitutions. And also any comment that I make would fall short of the investment of the UN in special rapporteurs on freedom of religion or belief, having visited each of these contexts that questions have been posed to me on, you know, for 2 or 3 weeks with experts, prior research, engaging people on the ground, various stakeholders, speaking to government and non-government authorities, and then producing their recommendations that, although not binding in law, must be persuasive. They have been, their authority has been vested in these special rapporteurs precisely to carry out this mandate on exactly this theme. So, for example, we see that China was visited by the special rapporteur on freedom of religion or belief, Amor, in 1994, Vietnam in 2014 by special rapporteur Bielefeld, India in 2008 by special rapporteur Jahangir. I appreciate that things have changed a lot and there is much concern in these contexts. But what we see is that the state stating in its constitution that it is a secular state does not prove sufficient in the full enjoyment. Maybe that's a far too pedestrian an observation to be making, but you know, the declared statement of the state regarding its relationship with religion or belief is far from sufficient regarding the actual enjoyment by everybody. If we remind ourselves, General Comment 22 is the standard that the Human Rights Committee is interpreting from the International Covenant on Civil and Political Rights, and it calls for no impairment and no discrimination by everybody, regardless, okay? Now, Jaclyn has also drawn our attention, if I put it in international human rights terms, that we don't only have freedom of religion or belief. This is underlined and extended, if you like, through minority rights. So minority rights provisions say that all persons belonging to minorities should be able to maintain their characteristics. That includes religious characteristics. And those religious characteristics may be combined with, intertwined with ethnic and linguistic characteristics that religious communities sometimes have. And that minorities, religious minorities in this case, should be allowed to, and sorry, I also insist that religious minorities means religion or belief minorities. that they should be able to develop and continue their characteristics. They should be consulted in matters that concern them, and they should be able to participate in public life. So it's not as if they are allowed to be in their cocoons and separated from wider society. They should be consulted in matters that concern them and also be allowed to contribute to public life. And I think Mark and Jaclyn and Benjamin have drawn attention to how they have contributed and helped to shape and supported public discourse in response to COVID as well. So I think I've gone a long way from what the intended response was, but I think we have the bottom lines, and you are closer to the ground and can apply it far more in the context. Democracy, majoritarian democracy, of course, is not some kind of panacea either. It needs to also be vigilant, dynamic, and responsive to the religion or belief realities at every level. Benjamin has emphasized the cultural, for example.
Thanks, Naz. There's another question that's come in, and I'm going to direct it to Benjamin in the first instance. It's from Jaclyn Chen from Melbourne Law School. And the question is, in light of the framework proposed, do we need to distinguish whether an act is driven, or perhaps inspired by religious or non-religious reasons? That is, if it's coming out of the words of a priest or monk to support, say, a political candidate or a policy with respect to, for example, COVID-19. Does it matter legally and normatively if it's being rationalized in that way or by more secular political considerations? So Ben, could I ask you to address that?
So hello, and thanks for the good question. I mean, I'll just keep my answer brief. I don't think it matters in a kind of a normative sense, but it does matter, I think, in an analytical sense, that I think it helps to be attentive to the multiple normative orders in which things are being, in which claims are being made, or the multiple normative registers. So I think, you know, being able to, for us to disaggregate or just to examine the contexts and the uses and the different ways in which these things are being deployed is in and of itself useful as an analytical move. But I guess the question is more: do we have to have is one style of argumentation more legitimate than another? And I don't really want to make a claim like that.
So Mark, there is a question for you from Jinmin Tang asking if you could speak a little bit about the plurality of the legal system in the UK. Has a legal argument been made that there is an unjustified restriction of Article 9 since, as you talked about, the Sharia, or what the Council of Scholars and Imams have said is subordinate to UK law?
I'm not aware of any particular litigation arguing to the effect that the non-recognition of Sharia law disadvantages the Muslim population. But I think one needs to have a full awareness that it is the law of the state which holds primacy. And clearly every religious organization has its own internal laws. Sharia is one example. Jewish law, Christian laws of all various shapes and forms, that like any association of people, they are governed by their constitutions and by their practices. Now, the British courts have for a long time recognized the right in arbitration, for example, to agree that the arbitration will be carried out in accordance with Sharia law, and then the UK domestic courts will enforce the result of that arbitration. So that's clear recognition and enforcement of Sharia law in that context. Where it's been slightly controversial is in the family law context and the extent to which Sharia courts have sought to involve themselves in decisions regarding the distribution of wealth upon divorce and whether children should live with one parent or another after some form of matrimonial breakdown. The current position is that clearly the civil court retains the primary responsibility to reach those decisions, but it's an accepted juridical principle that alternative dispute resolutions, including mediation, are preferable to having hard-nosed litigation concerning the future of the children. And so the courts will defer to Muslim practices and Sharia law in relation to those matters, whilst at the same time retaining an overall supervisory jurisdiction to make sure that any agreement brokered by dint of Sharia law processes are fair and just. But for the most part, the courts will lean towards recognizing and enforcing decisions reached through communitarian resolutions, including those brokered by Sharia law.
Thank you, Mark. There are a set of questions actually directed to Jaclyn about the communitarian context. And I'm going to try to, Jaclyn, kind of bring them together as I see. So they're asking in one phraseology we have from Muhammad Ibrahim from Indonesia. It seems that religious communities in Asian countries, he's saying, seem to be more willing to concur with the communitarian view of religious freedom. Do you agree? Do you think that this could be endorsed by others? Janin Chen has also raised this, what sort of social and political factors could either support or, in his question, is disrupt the communitarian consensus amongst religions in Singapore? And so to what extent can the individual and communitarian conceptions be reframed as contrast and starting positions? Are they different sort of starting positions? If we start from a position of belief in a theological sense versus starting from a position of non-belief in theological, that's kind of bringing them together, but they're all about the communitarian context. So maybe I can ask you to speak about that, how it's structured, what its implications are, how stable it is, whether it comes from different starting points.
Thank you. Those are really good questions and really big ones. Maybe I'll start with the question of whether there is something specifically Asian about a communitarian approach among religious communities here. Well, to start with, I think that we need to really do further investigation into this question. I think that in general, many religious groups would have a more communitarian, a more community-based perspective on the individual. After all, the individual is seen as embedded within the religion, as embedded within the religious community. But this is, of course, not sort of universally accepted, because in some sort of religions, there might be more an emphasis on an individual's personal relationship with God, rather than the individual's relationship with a community, with a religious group. So I think that it would be, I don't want to put forward any stereotypes about a specifically Asian approach versus a specifically sort of European or American approach. But I do think that different religious groups themselves, and even within a single religious tradition, you might see groups or communities that are more individualistic and communities that are more conducive to a communitarian approach. With regards to the Jianling's question about socio-political factors that could disrupt the consensus in Singapore, that's a very big question. I'm sure it's a question that actually keeps the Singapore government awake at night at times, because, and to some extent, religious competition is one of them. But if you look at the recent amendments to the Maintenance of Religious Harmony Act, it's not so much religious competition. I think that there is some consensus among religious groups here about the need not to engage in aggressive proselytization, but what they are concerned about is foreign influence. So you see that the recent amendments to the law has actually puts in place certain restrictions on foreign direction from foreign groups. It puts in restrictions on who can be in positions of leadership, that these people must be residents in Singapore or Singapore citizens or permanent residents and so on. So I think that it seems that moving forward, there is perhaps one of the key areas that seem to be problematic would be this sort of globalization and the impact of globalization and influence on the religious groups in Singapore. In general, I don't think that a communitarian approach is necessarily sort of restricted to only persons or groups that have religious beliefs. I hope I'm understanding this question properly. But insofar as we have different communities, there could be communities based on ethnicity, communities that are based on, you know, other forms of sort of associations, then communitarianism itself could sort of be a way to see how these different communities, how these different groups could live together peaceably. Again, I want to sort of perhaps make a caveat here, which is that obviously communitarianism, there are many forms of communitarianism, and that there is always that we must be very clear that communitarianism can be distinguished from a sort of a more authoritarian sort of top-down approach, which is essentially simply an excuse or a way to impose state overreach on groups.
Thanks, Jaclyn. I'm going to turn next to a question that we have from Mario Gomez, which is actually a general question. Mario Gomez from Sri Lanka. He's asking, have any of the speakers come across examples where the pandemic has heightened religious discrimination or increased a sense of persecution on the part of religious minorities? Speaking from Sri Lanka, he's saying there was some controversy of the denial of burial rights to Muslims who died from the virus through a public health directive. Maybe, since this general, maybe I can start with Ben and then Mark, Naz, Jaclyn, if you want to. Ben, any comments on that?
Hi, Mario. Thanks for the question. I mean, obviously, intra-religious issues are something I didn't have time to talk about in the presentation, but certainly I think you'd see similar trends in India. And one thing that I've commented on, I have actually an article on religion in the pandemic. It's on my academia.edu site if people are interested. And one of the observations I made looking across nationally at some of the responses has been that there's been very interesting differences in relationships among religious communities when there was, say, certain Muslim groups in a Muslim majority state being, being connected with events that, spread the virus, that the kind of differences in that group were handled in one way or cast in one way in public discourse, whereas in Sri Lanka, where you have obviously a Buddhist majority country, all Muslims were impugned in some of those controversies over burial practices there. And so sort of depending on what the composition of the countries were, you had very interesting kind of different types of responses to this. So certainly India is another, I think, interesting example. But of course, looking at responses in Malaysia is also an interesting contrastive example that you would also look at.
Thank you. Mark, did you want to?
Only ready to speak from an entirely UK perspective, which is that I would like to think that the fears of advancing one religion at the expense of another have been avoided. And a couple of examples where the state has positively helped in that direction. I'm aware that the Secretary of State for Health established a places of worship task force in which leaders of different religious organizations were invited directly into conversation with each other and with the department, so that the opening up of places of worship could be done in such a way that all faith groups equally achieved what they wanted. And then I think that the other general observation which I'd like to make is that although in certain European constitutional settlements one has not so much a state religion, but a favoured religion, a religion which by tradition has a particularly close association with the state and with government. One of the perhaps unintended consequences of the rolling out of anti-discrimination equality legislation is that there is now a statutory duty not to discriminate. So in other words, if you confer a favour on one faith group, then the anti-discrimination provisions serve to apply the same favour across the record and so on in respect of all faith groups. The analogy is often given that a rising tide will lift all the boats irrespective of size and importance. So I don't want to sound complacent, but I would like to think that in a European context at least, the prospect of disfavouring one organisation and not properly applying discrimination provisions would not lead to the difficulties that the speaker has mentioned.
Thank you, Mark. Nazila, did you want to? Yes?
Yes, certainly. I'd heard about that concern in Sri Lanka, and there are examples in other countries where, for example, many prisoners were released, but religious prisoners were held back largely. So I think in contexts of persecution and established discrimination, especially when it's directed by the government, where that persecution or discrimination is government-led in particular, because of the pandemic context that we're talking about, we should be particularly vigilant. So of course, limitations can be imposed on manifestation of freedom of religion or belief, including, the limitations in Article 18 specifically talk about public health being one such grounds for limitations. But that doesn't mean it's a carte blanche for the state. Those limitations must be, for example, necessary, proportionate, the least intrusive, and they must be non-discriminatory. And I think when it comes to cremation, or, our prime minister is saying, well, now you can go and live with each other, but marriage is still prohibited. I mean, I'm not saying he just said that as a fancy, but the circumstances, some people choose not to live together before marriage. So, but these are examples of indirect discrimination or in discriminatory effect that relates to some groups rather than others, or not all groups have places of worship even. So yes, I think it's something we should be mindful of. And it is hard to be aware of all groups and all the consequences, but I think what Mark described as consultations at the widest possible level can help preempt that.
Thanks, Naz. Jaclyn, I don't know if you have anything that you want to say on this. I have another question that I'll direct to you, but first, there is a question from Bo Chujanko from NUS, one of our fellows here at the Center for Asian Legal Studies, which I'm going to direct to our religious studies professor first, which is Benjamin. He said, I think sociologists, Weber, Durkheim, and anthropologists like Gertz agree that religious belief is inherently communal and nourished by communal rituals. And so communitarian religiosity in Asia, religiosity is not unique to Asia. Would you agree with that?
I agree with his assessment of the sociology of religion there. Yeah, that sounds right.
Okay, in which case, if that is right, then it maybe leads to one of the other questions, which I think we can direct to Jaclyn. This is a question that comes from Fazrihan, who is a PhD candidate at Paul Universitaire, Paul Euclid, if I'm pronouncing that correctly. It's a general question, but I'll turn to you first. What is your personal opinion on the state of communal integration of various religious groups around the world, considering that COVID-19 seems to have sparked an interest in eschatological studies, especially from Semitic religions?
Just one thing that's, I think, interesting to observe from a religious studies perspective is a growth of certain ecumenical movements in religious communities. So, for example, in there's lots of diverse types of Buddhism, and in a lot of places, there's been a movement to have groups that wouldn't normally conduct rituals together or collaborate on various types of religious events have started to do so. So I don't know if that's exactly answering your question, but it has sparked changes in the notions of membership and communality among religious subsects.
So Jaclyn, here is one that is specifically directed to you. So let me take you to that one, which is from Anisur Rahman in Bangladesh. He's asking, how can the state negotiate between the interests of community and religious groups in a country where religion plays an important role to politics and governance? And the example given is Bangladesh, where the government has had to open religious institutions due to pressure from religious groups.
So I was actually going to also respond to the earlier question,
Sure.
So maybe I'll respond to the earlier question first, because I think that there's something very interesting that we see happening, and it is the sort of, at least in some of the societies, the countries that I've looked at, but I will give you sort of more specific examples from Singapore, is an emphasis, as Ben was saying, on interfaith solidarity. An emphasis that, we have a commitment, we have a belief in something bigger, and that there are certain similarities in how we face a pandemic and how we face an outbreak like this, a crisis like this. And in the context of Singapore, what was very interesting is the very public and online exchange of letters between different religious groups on their holy days. So for instance, for Easter, the Mufti wrote to the National Council of Churches to express solidarity, saying that it is a contemplative time for our communities, and that our respective traditions again, pointing to the similarities, the commonalities, empower us with meaning, values, and lessons that can make us stronger and more resilient in the face of adversity. And then in exchange for Eid, the Catholic Church sent greetings saying, as Catholics during Lent, we share the spiritual disciplines of prayer, fasting, and almsgiving that you practice during Ramadan. And we saw also at Easter, we rejoice in God's great mercy and compassion as you do at Eid. So you see that that not only is there this sort of emphasis of interfaith solidarity, but this is done in a very public way because it has to be done online. So these letters then sort of went viral, and people could see this display of solidarity, which itself generates a certain amount of sort of goodwill among people who normally might not be paying attention to these issues. So I think that there is this the pandemic and the fact that we all have to go online and be online netizens right now has sort of this public, provides a public face to interfaith relations. With respect to the second question about how the state can negotiate the interests of the community, this really goes back to the earlier point I made, which is about religious capture. When you have religious groups that are able to exercise dominance and influence over governments, this can then lead to a problematic situation whereby groups are able to override or pressure governments by virtue of their influence among society. So it does set itself up for a very problematic situation if these religious groups do not see themselves as being aligned with the government in advancing the common good, in advancing the needs of public health.
Thanks very much, Jaclyn. And I think we are actually technically out of time, a little bit over time. So I'll bring our session to a close. I'm sure I speak on behalf of all of the participants when I thank all of you, our speakers today, for not only engaging presentations, but for a very rich discussion in the Q&A.